Now that it's almost 2018, you would think that no one, and I mean no one, would blame a sexual assault victim for the crime perpetrated against them, right? And that righteous indignation would be tenfold if the victims were, say, 9 years old, 3rd grade. Buckle up, because I'm taking you to Florida, specifically Palm Beach County, where a school board has just agreed to pay a major settlement after fighting a lawsuit for more than a decade. It involved 4 little girls, all of them in 3rd grade, who were molested by their teacher. A teacher who, by the way, pleaded guilty to child abuse, was kicked out of the school after all 4 girls reported to the police that he had touched them during reading groups and during movies. At least one of them said touched her under her clothes. He'd also asked them to put their hands on his crotch. Those are the facts. And while this one seems pretty open and shut, it was not. The school district actually fought the family's lawsuit. The Palm Beach County School District lawyers insisting that the girls were somehow partly responsible for their own molestation. Let that sink in for a second. For the past 11 years, they've been using something called comparative negligence. That's pretty fancy, but it was part of the defense, saying that the plaintiffs were old enough to appreciate the consequences of their own actions and to be held accountable for them. And that through their actions and omissions, these girls conducted themselves in a careless and negligent manner. And such negligence was a contributing and/or the sole proximate cause of their injuries and damages. Let that sink in. Attorneys maintained that it was their job to defend the school board and raise what they called certain legal defenses. But members of today's school board are saying they didn't even know that this language was being used in their defense.
In this case, it's been many, many years of suffering by these children who are now adults. Psychological damage has been done, and now they are adults. I am saddened about what happened to them. It certainly wasn't my idea, or I don't believe this school board's idea for this defense to be used or even mentioned in this process.
While the defense has now been officially dumped, the board's lawyer is trying to clean up some of the damage.
I want to make something very, very clear. Never was this defense ever used to blame these girls for the actions of their teacher, Blake Sinrod. Never. It was read out of context. It was never used that way. I can tell you, as someone who's been involved in litigating this case for years, never, and I can't shout never loud enough, but I want to make sure everybody knows that.
Well, thank you for that, Ms. Friedman. I don't know how that's read out of context. That was cut and dry. That was boilerplate. And what I just said on TV was what you said in the suit. But I'm going to tell you right now, that board is paying dearly for all of this, to the tune of $3.6 million, to be exact. But all of this, again, is more than a decade after Mr. Blake Sinrod molested those girls, and after more than a decade that the board told them they were somehow, maybe partly, but somehow, to blame as 9-year-olds, as 3rd graders. So those girls are now women, and they are in their 20s, and they are speaking. But as you can imagine, it's pretty embarrassing. It's pretty hard for them to go public. And of course, everybody should understand that. So I'm going to play for you some of their reaction, their comments. We are naming them as Janie Doe A and Janie Doe B. They spoke via telephone, and we've altered their voices because they want to maintain their anonymity in all of this. But first from Janie Doe A, where she talks about the length of time this took and what they went through.
It took 12 years to close this case and get what the system calls justice. We'll carry this pain forever. The settlement and the end of the case has freed us from the court system, but it can never take away our pain. This type of defense is what makes victims feel ashamed and embarrassed and afraid to come forward. We are not, and neither should any other survivor. It makes me feel disgusted that the school board used such a defense when their sole responsibility is to protect its students from any harm.
So Janie Doe B also spoke on that conference call. We've altered her voice as well, but she also goes further and talks about the anger that this bred.
It just makes me baffled and angry that they would even say something like that and say that 9-year-olds were accountable and allowed what happened, because it doesn't matter if you're 9 or 20 or 30 years old. It shouldn't be used that the victims allowed something like that, because that's, like Janie Doe A said in her statement, it makes the victims feel like it's their fault and they're ashamed.
Marc Wites is the attorney for the former students who were sexually assaulted. He joins me from Boynton Beach, Florida. Marc, thanks for being on. You know, it just defies logic. I want to say that this was an accident. I want to say that this was a mistake. This was boilerplate language that got lifted and put into a suit. Somebody checked it and said, oh, dear God, you can't say that about little kids in 3rd grade. But this went on for 11 years, and that language stayed there that whole time. Why?
That's the $64,000 question to which I don't really have a very good answer. You know, I have to tell my clients very often, all too often, that the wheels of justice grind slowly. This case is a testament to that. That defense has been present in all of the answers and affirmative defenses that were filed in the case by the school board. That's a fancy name for saying the defense to a lawsuit. There are 2 main documents in a lawsuit that are pleadings. One is the complaint, what the plaintiffs have to say. The other is the defense, or the answer, what the defendants have to say. You know, they say that actions speak louder than words, and the school board did write those words, and they did raise that defense several times during the course of the case.
Honestly, Marc, I'm guessing that over the course of 11 years, we've had school board member after school board member after school board member. It's almost like they're so far away from the chain, they can say, what a terrible thing that our predecessors did. But here's what I don't get. At some point along the line, and you correct me if I've read wrong, but there was an argument made that that language that they somehow are to blame pertained to the fact that they didn't get counseling and therefore their injuries are their own fault. Is that what they were hanging their hat on?
Well, what the school board said at the end of the case, and I take their lawyer at their word, because while they did raise this defense, it was asserted, it was part of the case, it would not have been used until there was actually a trial in the case. The case was resolved before there was a trial. What the school board lawyer was explaining was that this comparative negligence defense, they say, would have been used as it relates to damages. Their argument perhaps that because a girl didn't get enough counseling or any counseling or didn't get counseling during a certain period of time, that she might have been hurt less or injured less or wouldn't suffer as much. That's something that we categorically disagree with, but their argument is that they were raising this comparative negligence defense as to damages and not as to liability, but in the words that were written, the words that you quoted, it was raised as to both.
Your co-counsel over here, Randy Zellin, is shaking his head, and you've been shaking your head since you arrived at this building about this case.
It is so hard to be a lawyer. There is a reason why we are the butt of jokes and how people have prayed for our demise, including Shakespeare, though that's not exactly what he meant. My God. First of all, a 9-year-old can't even consent to any of those things. Second of all, it clearly goes, because it's what you do in a civil case. Oh, you claim that I did you wrong? Well, you know what? You're the reason why you got hurt, not because of me.
When it's grown-ups.
You can't do that. You have to just take 1 second and take a look at what you're doing and think about what you're doing. There's no excuse. Oh, I missed it. I lifted it from another pleading.
11 years of looking at the big picture didn't change.
Well, somebody could have made a motion to dismiss that defense also. But my God, you don't do that. It's not that defense.
It's indefensible.
Defensible.
It's indefensible. Randy, thank you for that, and my thanks to Marc Wites as well, and to the young women who You know, God, please, Mark, pass on our thoughts to them for having to endure this for so long. They got what they had coming, which is a $3.6 million settlement, and I don't even know if that'll scratch the surface in fixing the ills. Mark, thank you. Appreciate it. A 3-year-old toddler still missing.